Assalamualaikum and good morning to everyone. My name is Luciana Lu and my metric number is 271550. I'm your first presenter for today, and my group and I will be presenting about contract law in terms of tourism and hospitality industry. So for my part, I will be explaining three things, which is the definition, types of contracts, and also the formation of contract. Alright, let me kickstart with the first one, which is the definition of contract law. So, generally, contract law means agreement or a bargain made between two or more persons which create obligations that are enforceable at law or legally binding. Do you really understand what it means? Let me give you an example in tourism and hospitality industry, which also including accommodation, restaurants, tourism attractions, destinations, airlines, and transportation. So, contract law here doesn't just necessarily involve in huge agreement between large corporations. It could happen everywhere and even in your daily life. A person contract whenever he or she took bus, watch movie in cinema, buy groceries. So one example I can give you is Zul. He went to Four Seasons Hotel at Kuala Lumpur. So he wants to check in and he pays at the counter desk. So there's a receipt for him. So those are also considered at contract law because they are purchased because of the purchase, and it doesn't just necessarily mean in writing. So moving on, there are four types of contract, which is formal, simple, express, and implied. So formal contract here is very common, general, which means contract where the parties have signed under seal and delivered. And simple contract can be divided into two. First is unilateral and bilateral. It means simple contract is either written and not under seal or oral agreements. So unilateral means one, and it was written by one party and only one party obligated to those terms. Meanwhile, bilateral means two or more. Okay, so meaning that the terms and conditions are negotiated between two or more parties. And express and imply means that one that said in words, either oral or written, one that is inferred of the actions and conduct of the parties involved, respectively. In order to form a contract, this element must be presented. So take a look at the first one, which is the offer and acceptance. An offer means exchange for something. For hotel travel agents and operators, a contract arises from the telephone conversation or walk-in inquiry. And then the hotel front desk will email or fax a formal offer for them for a secure booking. This means that offer must be communicated to the offeree, who has option to accept and reject it. Second is acceptance. Means you agree with the offer and you accept it. Must match with the terms of the offer as well. Responses like, I accept, but my acceptance is subjected to, this means it's counter offers, which can lead the original offer to be destroyed or terminated. Consideration. This also falls under one of the vital elements in contract, refers to price paid in exchange or the fulfillment of a promise. Tangible items, a written promise, and forbearance are the examples. And the fourth one is intention, to create legal intentions. Two parties have the intention to create legal relations, means they are legally bound by agreement. If one fails, it can be conducted to the court. Domestic means no intention to create legal relations. Commercial means there is intention to create legal relations. And the last one is capacity. Capacity can be explained as a person who contract has the ability to understand the terms of contract. So under the section of Contract Act Section 11, minor and person who of unsound mind lack of capacity to contract. For example, there is a minor who wants to book contract for holiday. Can he? The answer is no, because guardian or adult or parents need to enter into booking contract on the minor's behalf, because some of the booking contract in hotels needs to be above 18. That's all from me. And let me emphasize for the last time, if any of these elements are missing, for example, there is no consideration or there is no acceptance between both parties, the contract are automatically considered as void.
Thank you to the previous presenter. So my name is Mubasyir bin Zulhaidi and my metric number is 271632. So basically today I am going to talk about factors that could affect the validity of a contract. So as we understand more about contract law, simple contracts are not all enforceable. So it might be because of first, unenforceable due to lack of capacity, not in writing, agreement is unconscionable, or second, voidable, that is originally legitimate but one side has the choice to avoid or affirm the agreement. Third is void or had never existed, and the last one is prohibited by the law. So next we are going to find out the factors that could affect the validity and enforceability of a contract. First is misrepresentation, second is capacity, third is mistake and frustration, fourth is duress, and fifth is privity. So what is the definition of a misrepresentation? A misrepresentation is an assertion not in accord with the facts that is made with the intent to mislead or deceive. As such, it can constitute fraud. So there are three types of misrepresentation. First one is innocent misrepresentation. Second is fraudulent misrepresentation, and third is negligent misrepresentation. So an innocent misrepresentation is a false statement of material fact by the defendant who was unaware at the time of contract signing that the statement was untrue. So the remedy in this situation is usually rescission or cancellation of the contract. Next is a fraudulent misrepresentation. A fraudulent misrepresentation is a statement that the defendant made knowing it was false or that the defendant made recklessly to induce the other party to enter a contract. So the injured party can seek to void the contract and to recover damages from the defendant. So the last one is the negligent misrepresentation. These types of misrepresentation is a statement that the defendant did not attempt to verify was true before executing a contract. This is a violation of the concept of reasonable care that a party must undertake before entering an agreement. Moving on to the second factor, that is the capacity. So what is a capacity? A capacity is simply the ability or competence to enter into a valid contract or legal agreement with another party. Capacity having capacity to contract means a person is legally competent to enter into a contract. The capacity to contract is defined as having the capacity to enter into a legal agreement, which means someone must be of sound mind. With legally binding agreements, some people don't have the capacity to enter into an agreement, whether they are underage, mentally ill, or intoxicated. Next, the third factor is mistake and frustration. Starting off with mistakes, there are a few different types of mistakes. For instance, a common mistake where the mistake is shared by both parties regarding a fundamental matter of fact. Second is a mutual mistake is when the parties to a contract are both mistaken about the same material fact within their contract. And lastly, a unilateral mistake where only one party is mistaken, so the other party knows about it and takes advantage of the error. Next is frustration. Frustration is an English contract law doctrine that acts as a device to set aside contracts where an unforeseen event either renders contractual obligations impossible or radically changes the party's principal purpose for entering into the contract. So the fourth factor is duress, that refers to the act of using threats or psychological pressure to force someone to behave in a way that is contrary to their wishes. So the fourth factor is duress, that refers to the act of using threats or psychological pressure to force someone to behave in a way that is contrary to their wishes. In contract law, duress is used as a form of defense to a crime where the defendant uses threats to force the plaintiff to commit a crime that is against their wishes. a party who is forced into an act or contract under duress can rescind the contract, rendering it null and void. The last factor is the privity of contract. Privity is the doctrine of contract law that says contracts are only binding on the parties to a contract, and that no third party can enforce the contract or be sued under it. So lack of privity exists when parties have no contractual obligations to one another, thereby eliminating obligations, liabilities, and access to certain rights. Under the doctrine of privity, for example, the tenant of a homeowner cannot sue the former owner of the property for failure to make repairs guaranteed by the land sales contract between seller and buyer, as the tenant was not in privity with the seller. So privity is intended to protect third parties to a contract from lawsuits arising from that contract.
Thank you to Mubasyir for the presentation. I am Wen Ting. Metric number is 2811134. Now I will continue present about brief of contract. Brief of contract can know as a violation of any of the agreed upon terms and conditions of a binding contract. The brief could be anything from a late payment to a more serious violation, such as the failure to deliver a promised asset. A contract is binding and will hold weight if taken to court. To successfully claim a breach of contract, it is imperative to be able to prove that the breach occurred. While contract consists of all types of legal agreements and terms, breaches themselves are classified in just a few ways. Among the four main classifications are material breach of contract, minor breach of contract, anticipatory breach of contract, and actual breach of contract. I will briefly explain about the four main classifications of breach of contract. First is material breach of contract. Material breach occurs when one party receives significantly less benefit or a significantly different result than what was specified in a contract. Material breach can include a failure to perform the obligation laid out within a contract or a failure to perform contract obligation on time. When a material breach occurs, the other party may pursue damages related to the breach and prove its direct. Next is minor breach of contract, sometimes also called as partial breach of contract or immaterial breach of contract. This contract refers to situations where the deliverable of the contract was ultimately received by the other party, but the party in breach failed to fulfill some part of their obligation. In such case, the party that suffered the breach may only be able to pursue a legal remedy if they can prove that the breach resulted in financial loss. A late delivery, for example, may not have a remedy if the breach party cannot show that the delay resulted in financial consequences. Continue with anticipatory breach of contract. This breach of contract need not actually occur for the responsible party to be liable. In the case of an anticipatory breach, an actual breach has not yet occurred, but one of the parties has indicated that they will not fulfill their obligation under the contract. This can occur if the breaching party explicitly notified the other party that they will not fulfill their obligation. But such a claim could also be based on actions that indicate one of the parties does not intend to or will not be able to deliver. Last is actual breach of contract. An actual breach of contract refers to a breach that has already occurred, meaning the breaching party has either refused to fulfill their obligation by the due date or they have performed their duties incompletely or improperly. When a breach does occur, there are several types of remedies the other party may pursue. These included compensatory damages, to address direct economy loss stemming from the brief and consequential loss, which are indirect loss that go beyond the value of the contract itself but are the result of the brief. That's all from me. Now I will pass to Zulkifli. Thank you.
Hi, thank you to the Wen Ting, and now I will continue my part. Before that, my name is Zulkifli bin Halim and my metric number is 271608. I will talk about the advantages of contract includes provide proof of what was agreed between you and the other party. Second, help to prevent future misunderstanding or disputes by making the agreement clear from the beginning. Third, give you security and peace of mind by having the terms of the agreement down on paper, which the terms do not change. 4. Reduce the risk of a dispute regarding payments, responsibilities, and time frames that the service to be performed under the contracts. 5. Sets how disputes will be resolved. 6. Specifies how either party can end the contract before the work is complete. In contract law cases, there are so many cases related, but among of the well-known cases is Oli v. Marlborough Court Ltd. The fact of this case is, Oli was a guest in the defendant hotel. On arrival, Oli paid for a week's board in advance and then went to the room. In the room, a notice was displayed stating the proprietors would not be responsible for any item lost or stolen unless handed to them for safekeeping. Oli left the room and deposited her key on the board reception before leaving the hotel. The key was taken and several items were stolen from the room. Oli sought damages, negligence, help. In addition, contract law can also be improved by speeding up legal proceedings. One of the legal problems that is often looked at by the society is the lengthy processing of cases. Thus, for example, lawmakers must be able to improve their system by speeding up the case resolution. In addition, the contract law also needs to be improved by improving the assistant witness system. With CCTV footage alone is not enough, as evident therefore in the contract agreement. Later should be included the name of the witness with the appropriate number. In conclusion, we believe that contract law seeks to provide contracting parties in appropriate legal structure for resolving conflict and enforcing their contractual obligation. By that, we also understand that the defendant and plaintiff need to follow the arrangement and the decision made by the court. When one breaches the contract law, they have every right to claim back their rights as the contract terms are truly agreed and consented by both parties.